While the Michelle Troconis trial is underway, there's already been 2 days of trial. The question is whether there's going to be a trial day tomorrow on Tuesday, and the reason why they're not sure about that is because there's supposed to be a very wintry storm passing through, and they may have to close the courts for that. So we're kind of just going to have to sit and wait and see what happens with whether trial is going to continue on Tuesday. But the first 2 days of trial were mostly uneventful, nothing too exciting, except that on the first day there was no opening statements, which needed an analysis, which I did provide. If you haven't seen that yet, go check that out in the video that I posted about why there's no opening statements and whether that's even whether that's a constitutional right of a party to be able to have an opening statement. So we discussed the entire law about that. Go check that out. But on the second day of trial, there's an interesting motion that the defense made with respect to what they termed presumptive blood testing. And presumptive blood testing, the reason why they termed it that way is because that's the language that is used in the Connecticut opinions when referring to these types of tests. Now, what type of tests are we talking about? We're talking about the tests that the police officers or detectives use they use a certain test where they spray a certain substance, a certain chemical, either luminol or what they refer to as KM, and that chemical is supposed to make a reaction if there is blood in a certain area. So if there's blood, then if you use this test, this presumptive blood test, then it will make a certain reaction, and you'll be able to tell where the different blood spots are. So the defense made a motion that this information, this presumptive blood testing, should not be admitted into this trial. And this is very significant because in the Michelle Troconis case, you've got blood spots in the garage, blood spots on the car, and there's going to be blood spots in a bunch of different places. And they used this chemical in a lot of the different areas, and to be able to show that there was actually blood here is actually going to obviously help the prosecution's case a lot, to show that there was actually blood. Where do you think the blood came from? Obviously it came from the victim here. So but the defense is saying that should not be allowed in at all. It's not admissible. So what's the basis of the defense's motion? You can't just, like we always say, you can't just say, hey, I don't want that piece of evidence, and you've got to bring a legal basis for it. So we're going to go explore some of the case law about what they were arguing about during the trial and what the judge analyzed. And maybe you were watching the trial not knowing exactly what was going on, but this will also help you understand why the witnesses talk in a certain way, because they have to follow certain rules within the case law. So let's jump into the cases which govern this specific area of law. And remember, we're in Connecticut, so these are all going to be Connecticut cases. So you have the first case, which we're going to discuss, is State versus Schaefer. State versus Schaefer was a case in 1975 by the Connecticut Supreme Court. And in this case, what happened was that there was a witness who testified that it appeared to her or him that there was blood on the window of the defendant's car. So obviously very incriminating. You have the defendant there who was charged with murder, and there's blood. At least this witness is testifying that they see blood on this defendant's window of their car. So the defense objected to that witness being able to say that. Why? Because how do you know it's blood? This is just, you are a regular person, and we know that sometimes you need expert witnesses. So who says that your observations are correct? You're not an expert in blood analysis. You don't know really whether it was blood or maybe it was something else. So therefore, that was the basis of that objection. Now, the court held the following. I'm going to read it for you. The court held, when the question involved can be answered by the application of ordinary knowledge and experience, expert testimony is not required. When do we need experts? We need experts when you're talking about a specialized area where we're not all familiar with. But if a regular person is familiar with something, then he can tell you what he saw. So even a regular person who's not an expert, who doesn't deal with blood analysis all day, can tell you when something's blood or not. So that's what this court held essentially. This court held essentially that you don't need to be an expert. Even a regular person can tell you that there was blood on that window, or what looked to him like blood, or what looked to her like blood on that window. And then they just conclude the following: although to render opinions of common witnesses admissible, it is indispensable that the opinions be founded on their own personal observation. So if you want to admit this type of evidence, this type of what they call opinion evidence, because essentially the witness is saying their opinion that this is blood, it has to be based on their personal observation and not on the testimony of others or on any hypothetical statement of facts as is permitted in the case of experts. So when it comes to experts, you are allowed to ask an expert witness a hypothetical question. That's completely okay. And you're also allowed to ask them based on the testimony of others, certain questions. But when it comes to a witness giving an opinion on something that's common knowledge, something that they experience in their common knowledge and experience, so then it just has to be based on their personal observations. So it can't be based on these other things like testimony of others or hypothetical statement of facts. So that's the entire caveat that this case gives, State versus Schaefer, and therefore it's clear that a witness can say that this window had some blood, and it turns out that that blood was the blood from the defendant. Okay, so that was that first case, State versus Schaefer. Now let's go to another case. That was in 1975. There's a case called State versus Whipper, also Connecticut case in the Supreme Court. And this was a 2001 case. So this is a number of years later. And this is what they held in this case. Listen to this and tell me if you see the problem. We agree with the defendant that in light of the state's failure to test the stain for the presence of blood, it was improper for the state's witness to testify and for the state's attorney to argue that the palm print found on the vase had been made in blood. So essentially what happened in that case is that the allegations were that the defendant took a vase or a vase and smashed it over somebody's head. And there was a palm print that was found on the vase, and there was testimony that it was bloody, that it wasn't just a palm print, but the palm print was bloody. So the question was, and this is what the state argued in their arguments, and also for the state's witness to testify, that it was actually blood. It was a blood print on the vase. So is that okay or not? Well, if you'd ask me from the State versus Schaefer case, you would say, sure, there's no problem. Even if it's not an expert, because you got a regular witness saying that, yeah, sure, that looked like blood to me. However, this is what the State versus Whipper case said. We agree with the defendant that in light of the state's failure to test the stain for the presence of blood, since the state did not test that was actually blood, they didn't do any testing, they just relied on the witness's account that, yeah, sure, it looked like blood. So the fact that they did not test it for blood, it was improper for the state's witness to testify and for the state's attorney to argue that the palm print found on the vase had been made of blood. Although Finkel had assumed that the substance was blood because of its reaction to certain chemical reagents, it could not be determined for certain whether the stain was indeed blood. So even though they actually used the presumptive blood test here, but since the only other thing they had was this witness's testimony that it was bloody, so that's not going to be good enough. They said it's not good enough. So now we have a problem because we have a contradiction between State versus Schaefer and State versus Whipper, right? Because State versus Schaefer said, yeah, a lay witness could say that it's blood, and here you have State versus Whipper, which not only have a state saying that it's blood, but they also did this presumptive test, and the presumptive test also said that it's blood, and still that was not good enough. So that is the problem. We have a contradiction between these two cases. So before we get to the case which rectifies this contradiction, which takes care of this contradiction, which tells us which case to ignore and which case to go with, we're first going to talk about a different case, which is also a very important Connecticut case, which both the attorneys were talking about as well as the judge. And that is the case of State versus Moody. State versus Moody, if you want to look it up, it is a gruesome tale. So if you just ate, maybe it's not a good idea to read that case. Some vicious murders in that case. So, but we're not going to go through all that in this channel. We're just going to talk about the main issue here. And the main issue in this case was that there was certain blood on a shoe. There's a blood on a shoe, and they did this presumptive test. Again, they tested it with these agents on the shoe. And what do you know? They had an expert, actually in this case they did have an expert testifying about that according to this presumptive blood test, it is possible that was blood, blood on the shoe. And not only that, but one of the questions The juror, sometimes the jury has a question. Well, one of the questions that the jury asked was that they wanted to hear the testimony again about, and I'm going to quote it, about what shoe blood found on. That was the language of the question. So you see that the fact that they felt that there was actually blood on this shoe weighed very heavy on the jury's mind. And that actually plays a big difference in the outcome of how the Supreme Court found in this case. So this is what the Supreme Court found in this case. I'll get bulky your seatbelts because it's very, very strong words. So they talk about the expert witness who was called to testify, and the expert witness did say that this presumptive test doesn't mean that it's automatically human blood. It can be other things. It can be animal blood, and it can be something other than blood. So the expert acknowledges that it could be other things. So this is how the court analyzes this. The first test of admissibility of any evidence, the first test, and this is again the first rule really that you learn in evidence, at least this is the first rule that I learned in evidence, is that whether it is relevant. Is this evidence relevant? We have reiterated that evidence is relevant only when it tends to establish the existence of a material fact or to corroborate other direct evidence in the case. So, does it tend to establish the existence of a material fact? Does it have any tendency at all to establish the existence of a material fact? Or does it corroborate with other direct evidence in the case? We have noted that evidence is admissible when it tends to establish a fact and issue or to corroborate other direct evidence in the case. Okay, they just restated it from another case. One fact is relevant to another fact whenever, according to the common course of events, the existence of the one, taken alone, or in connection with other facts, renders the existence of the other certain or more probable. So does it make it more probable that this was a murder or not? If it makes it a little more probable, then it's relevant. Listen to this language. In the present case, the result of the presumptive test for blood has no probative value whatsoever. Can you ever hear such strong language? Again, in the present case, the result of the presumptive test for blood has no probative value whatsoever. There is absolutely no value that this presumptive blood test is giving us. The fact that they did this test is just as well as if they didn't do the test. It's not giving us any additional information. The test result did nothing toward establishing the likelihood of the presence of human blood on the sole of the defendant's shoe. Therefore, we hold that the test result was entirely irrelevant, and thus the trial court abused its discretion by admitting it into evidence. So in that case, it was allowed to come into evidence. The Supreme Court quite clearly said that no, it cannot come in. It was not supposed to come into evidence because it had no probative value whatsoever. Now, you may be thinking, it has no probative value whatsoever? It has no value? I mean, at least you're narrowing it down, right? You see a spot on a shoe. You have no idea what is that a grass spot? Is that a mud spot? So at least the presumptive blood test can narrow it down to a smaller category of things. It is providing some helpful value to at least say that it can't be anything in the world, but yet this Supreme Court felt that it had no probative value whatsoever. Very, very strong language about this. So that's the language, of course, that the defense in this case, the defense for Michelle Troconis, quoted in their motion. Said, look, this case, this is a Supreme Court case of this Connecticut. It's Connecticut Supreme Court case, and it says that this presumptive blood test has no probative value whatsoever, and therefore it should never be admitted in a trial. What a strong argument. Doesn't that sound like a strong argument? Well, now let's get back to our original contradiction, and then everything will become clear. We had this original contradiction between State versus Schaefer and State versus Whipper. One case held that a regular witness can give an opinion about whether something is blood, and the other, State versus Whipper, seemed to say that they cannot. So this is what Now we get to State versus Grant. State versus Grant is a 2008 case. So this is a case after the 1975 case, after 2001, and after State versus Moody, by the way, which was a 1990 case. And this is what they said. Now, of course, lawyers will always try to make, whichever side you're on, you're going to have to argue for your side. So the prosecution, the state in this case, argued that there's no contradiction. And you got to be a little bit, you got to think a little bit outside the box and try to figure out a way how to make State versus Schaefer be consistent with State versus Whipper. And that's what the state tried to do, but the Supreme Court didn't buy it. So the Supreme Court said the following. We agree with the defendant that Whipper is inconsistent with Schaefer. Sorry, you're not getting out of that. No matter how creative the state wants to be, you're not getting out of that contradiction. And we're going to have to do something with this contradiction. In Whipper, this court stated that the testimony of the police detectives, based on their personal observations that the palm print on the vase had been made in blood, was inadmissible because it could not be determined for certain whether the stain was indeed blood. In Schaefer, however, we had concluded that lay testimony based on personal observation that a substance on a car window appeared to be blood was admissible. In Moody, however, this court had concluded only that expert testimony that a substance may have been human blood was inadmissible as non-probative because it was based solely on a presumptive test that could not rule out the possibility that the substance was animal blood or some other substance. The stain at issue in Moody had been too small for more conclusive testing. Presumably, therefore, it had been too small for a person of ordinary knowledge or experience to make any reasonable inferences about its nature on the basis of personal observation. So let's pause for a second and explain what this means. In Moody, when the court held that this presumptive blood testing has absolutely no probative value, the reason for that is because that was all they had to go on. There was no other evidence that was pointing to the conclusion that that spot on the shoe was blood. The only thing that they had was this presumptive blood testing, which, you're right, narrowed it down, that it wasn't, let's say, a grass stain or a mud stain. It was within a category of blood or some other substances, but that's all they had. That's all they had to go on. So when that's all the expert has to go on, this presumptive blood testing, so that's when Moody said that no, it has no probative value whatsoever. So that's the first step. Now they continue. Having concluded that Whipper and Schaefer are inconsistent, you're going to have to go with one. So which one should they go with? Should they go with Whipper or should they go with Schaefer? Should I give you 10 seconds to think about it? Which one should they go with? Okay, I won't. Well, they says, we are convinced that Schaefer sets forth the better rule. Schaefer, 1975. Those justices know what they were talking about. The ones in 2001, they must have had something interesting for breakfast. But 1975 are correct. And this is what they say. A person of ordinary knowledge and experience generally is competent to testify that a substance personally observed by that person appeared to be blood. Right? That it makes a lot of sense. You can testify about what something appeared to you to be blood. You're not stating absolutely, and I know it because I tested it and I'll bet my life on it. You're saying that from your regular, ordinary experience in life, that spot on the defendant's window appeared to be blood. And we can accept that. Although the particular facts and circumstances surrounding the witness's observation of the substance might affect the weight to be given to the testimony, meaning if this was at night and the car was going 100 miles per hour, and that's when you're saying, oh, that appeared to be blood, certainly the jury can take that into consideration about what weight to give your testimony. But the fact that the substance was not subject to scientific testing to rule out any possibility that was not blood does not render the testimony inadmissible. So it is admissible. It's admissible for a lay witness, what we call a regular person, to go and testify about what appears to them to be blood. Now, of course, the facts surrounding their observation is very important. And like I said before, if it was at night and you were a far distance away from the car and something was shining in your eyes and you just woke up, I mean, all those facts, of course, go into the weight given, but it doesn't mean that something is not admissible. Something could be admissible and just not have a lot of weight on the jury. So they're making a very clear distinction here that yes, it's admissible, and this is just a question of how much weight the jury is going to give it. In the present case, the defendant relies solely on Moody and Whipper in support of his claim that the trial court improperly admitted the testimony of several witnesses that they had observed blood at the scene of the crime. As we explained, however, Moody stands only for the proposition that when the sole evidence that a substance was blood is the result of a presumptive testing method, that does not rule out the possibility that the substance was not human blood. The evidence is non-probative. So again, in Moody, it's when the only thing you have to go on is the fact that this presumptive blood testing was done. If that's the only thing you have to go on, then that's non-probative. But when you have other factors which can also point to the direction that this, or the conclusion that this is blood, then we could introduce it as evidence. In the present case, the testimony concerning blood that was found at the crime scene was based on personal observations by the witnesses under circumstances that would permit a person of ordinary knowledge and intelligence to conclude that the substances were blood. So here you have State versus Grant saying, hold on, hold the horses. Don't, as the defense wants to take it in this case, that, oh, you see that it's never admitted, it's never admissible. This presumptive blood testing is never admissible. In fact, Moody says straight out that it has no probative value whatsoever. Stop. No, that's not what Moody said. What Moody said is that when that's the sole basis for the prosecution to hang their hat on, that this is blood, then it's not probative. But when you have other circumstances and you have other evidence that points to this being blood, then it certainly could be admissible the same way a lay witness can testify about something that it looked like blood. So that is what State versus Grant said. So now, the judge went back, reviewed all of these cases. There was a long recess. The judge went back, reviewed these cases, and therefore the judge came back on the record. And when trial was about to start again at the end of day 2, he said, we are going to allow the presumptive blood testing in. We're going to allow it in because over here, there's other factors involved. There's other factors involved, including the fact that there was a missing person, and they were called down to the house, and there's some other factors here which could also suggest that this was actually blood, and it's not just solely based on the presumptive blood testing. And that's what he felt. But he made some very interesting points, because as testimony was coming out, and also what he did was, which is what happens sometimes, is that there's some other issues with respect to this testimony, which we're not going to get into just in this video. But because there were some other issues with this specific testimony, he sent the jury out and he said, let's do an offer of proof. An offer of proof is when you have both sides questioning this witness not in the presence of a jury, and this way the judge can hear the complete bit of testimony, which is about this argument that both sides have about whether this is admissible or not. He can hear the testimony come out, he can hear the cross-examination, and then he can make his ruling based on what he hears already. Sometimes it's hard to anticipate everything. So he'll send the jury out, he'll have the witness questioned by both sides, and then he'll make a decision about that point whether to allow certain testimony in, or certain avenues of questions you can't go to, or certain things like that. So that's what happened here. And what after this offer of proof, what we call an offer of proof happened, the prosecutor asked her questions, the defense attorney asked his questions, the judge made some interesting observations. Okay, and one of the things that he said is that one of the things that the detective was talking about when he was talking about this presumptive blood testing is that he was talking about a positive indication. I'm going to put that in quotes. Positive indication. He also said a false positive. Now, thinking about it, he says, I don't really like that terminology. And I think he's got a very good point here. When you say positive indication, to the detective, when he says it has a positive indication, he's referring to a positive indication of blood. Now, we know that this presumptive blood testing could be positive. It can have that chemical reaction even when there's no blood there. So let's say this has a chemical reaction. The chemical reaction happens, but it's not blood. Would you call that a positive indication? Well, you should, because the chemical reacted in a certain way. That should be a positive indication. But the way that the detective is referring to it as only a positive indication when it's blood. So he said right away, that may be a little confusing to the jury, and I'm not sure if we should use that terminology. And number two, he said, also a false positive. What's a false positive? Well, to the detective who's testifying, a false positive is if the chemical reaction happened, but it happened because there was no blood there. It happened because there was rust there or some other chemical that was reacting to it. Now, the judge says, how can we call that a false positive? That's not a false positive. That's actually a positive. It's just not the blood causing it to react. It's some other substance causing it to react. So he didn't like that terminology either, and he thinks that can also be confusing to the jury. Finally, he made a mention that the training that the police go through when they do this presumptive blood testing is only to train them about when the testing shows you blood and how to analyze it. I guess, the blood splatters or the blood patterns, if this is actually blood. So assuming this is blood, that's how the police are trained when they're using this testing. But they're not trained if, let's say, what's reacting is not blood. Let's say the substance reacting is rust or some other substance that's causing this chemical reaction. So they don't train them about how those reactions should look and how it should, look after the testing and how to analyze it, etc. So he kind of left it off as he has to think about this, about what type of cautionary instruction or how exactly he should allow the prosecution and the detective to answer these types of questions and what terminology to use so that it won't confuse the jury about what type of reactions are happening and whether it's blood or not blood and things like that. So I thought that was a very interesting, and I think that this judge is very thoughtful with some of his rulings. So that's the story with the presumptive blood testing. That's the excitement that happened on the second day, really. And now we will see if this trial continues on Tuesday, tomorrow. If not, then maybe Wednesday, maybe Thursday, whenever the storm is done. We got to wait for Mother Nature to be done, and then we can continue this trial. All right, that'll be it for now. Please, if you haven't subscribe, like the video, and we will see you next time.